بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيد المرسلين وعلى آله وأصحابه الطاهرين ما دام ما في السماوات والأرضين رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي اللهم علمنا ما ينفعنا وانفعنا بما علمتنا وزدنا علما اللهم إنا نسألك علما ينفعنا ويرفعنا اللهم إنا نسألك علما نافعا ورزقا واسعا وعملا متقبلا وشفاء من كل داء وبعد. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. All thanks and praise due to Allah subhanahu wa ta'ala for His many blessings that He has bestowed upon us. We beseech Allah subhanahu wa ta'ala to increase us in those blessings. By His grace and mercy, we have reached lesson number 5 in terms of our reading of Umdatul Salik, and we are focusing on Islamic contract law and related issues. In today's lesson, we're going to start with the subchapter dealing with Riba. The text reads as follows. The first thing which our scholars look at would be the meaning of the term Riba. There is a literal meaning to the term, and then there is a technical meaning to the term. The literal meaning of the term Riba, it refers to az-ziyada, an increase, and it is used in this particular sense in quite a few places in the Holy Quran. Allah subhanahu wa ta'ala says, وَتَرَى الْأَرْضَ هَامِدَةً, you will see that the earth is barren. فَإِذَا أَنزَلْنَا عَلَيْهَا الْمَاء, when we send down rains, اهتزت وَرَبَتْ, and then the earth moves, وَرَبَتْ, and you will find that the vegetation increases. So the word rabat from raba yarbu, which means to increase. So the literal meaning of the term riba would be to increase. Importantly, or what concerns us really, would be the shar'i, would be the technical meaning of the term riba. When we employ the term riba, we are not employing it in the literal sense, but rather we are employing it in the technical sense. So what does it mean technically? Our scholars have the following to say. عقد على عوض مخصوص. The word riba refers to a contract. There's a contract between two contracting parties. على عوض مخصوص, relating to a particular commodity. These commodities are what we refer to as usurious items. In terms of the hadith, which we are going to mention shortly, there are 6 such items. So getting back to the definition, it is a contract, and the subject matter of that particular contract in terms of the price and in terms of the counter value, those items, the price and the counter value, it happens to be a usurious item. An example would be gold. Gold is a usurious item. So I'm selling you gold in lieu of gold. Back to the definition. عقد على عوض مخصوص. It is a contract, and the subject matter is a particular commodity, one of the 6 goods found in the narration. نعم. غير معلوم التماثل. When there is not equivalence. And what do we mean by equivalence? Equivalence in terms of the Sharia. So for example, I give you 10 grams of gold and you give me 15 grams of gold. There's non-equivalence here. Usurious item. There's non-equivalence in terms of the price and the counter value, and Allah subhanahu wa ta'ala knows best. حالة العقد, at the time of the contract, أو مع التأخير في البدلين, or it could very well be, and here we find an extension in terms of the definition of riba. Riba doesn't simply translate as interest. The term riba is much broader than the term interest. So again, and repetition is beneficial for a believer, repetition is beneficial for a student. So I'm going to run from the beginning of the definition once again. What is riba? Riba is an aqd, it's a contract, ala iwadin makhsusin, when the subject matter of that contract happens to be a usurious item like gold for gold. غير معلوم التماثل في معيار شرعي. There's non-equivalence from a Shari perspective. The example would be, I sell you 10 grams of gold for 15 grams of gold in lieu of 15 grams of gold. That's the first part of the definition. The definition continues. حالة العقد, this is at the time of the contract. Or, and so now we're going beyond. What do we speak about now? أو مع تأخير أحد البدلين. What happens is I'm giving you 10 grams of gold for 10 grams of gold. But what happens? You giving me your 10 grams now, and I'm going to give you my 10 grams a week later. So here we have the deferment of either the price or the counter value. This also falls under the ambit of prohibited and proscribed riba, and Allah SWT knows best. Either both is deferred, both the counter value as well as the price, or ahadima, or one of the two, and Allah subhanahu wa ta'ala knows best. To sum that up, we look the meaning of riba, we've looked at the literal meaning, and we've looked at the technical meaning. We continue. The next issue which we're going to be looking at would be, what is the proof in terms of riba being proscribed? The proof here comes both in the form of the narrations of the Prophet ﷺ as well as certain Quranic verses. Let's look to the Quranic verses now. It reads as follows. أحل الله البيع وحرم الربا. The first issue would be that Allah subhanahu wa ta'ala says أحل الله البيع وحرم الربا, that Allah subhanahu wa ta'ala had permitted the sale وحرم الربا, and Allah subhanahu wa ta'ala has proscribed the sale. أحل الله البيع وحرم الربا. Allah subhanahu wa ta'ala has made permissible the sale, and Allah subhanahu wa ta'ala has proscribed riba. Now, there are certain other verses as well. There's a number of verses in the Holy Quran that relates to riba. The first one we mentioned now. There's another verse which says, Ya ayyuhalladhina amanu attaqullah, or you believe, be conscious of Allah, follow through on His commands, stay away from His prohibition, وَذَرُوا مَا بَقِيَ مِنَ الرِّبَى, and leave off that which remains of interest. And there are quite a few other verses as well. Allah subhanahu wa ta'ala talks about وَمَا آتَيْتُم مِّن رِّبًا لِيَرْبُوَ فِي أَمْوَالِ النَّاسِ فَلَا يَرْبُو عِندَ اللَّهِ. That which you give as interest in order to increase the wealth of people does not increase by Allah subhanahu wa ta'ala. Allah talks about the Jews before. Allah talks about the Christians, وَأَخْذِهِمُ الرِّبَا وَقَدْ نُهُوا عَنْهُ وَأَكْلِهِمْ أَمْوَالَ النَّاسِ بِالْبَاطِلِ, and وَأَخْذِهِمُ الرِّبَا, and because they appropriated, they used to exact riba from people, and Allah subhanahu wa ta'ala talks about that in a negative term, in a prohibitive way, and Allah subhanahu wa ta'ala knows best. So there are many verses in the Holy Quran that clearly proscribe riba. Then we look to the narrations of our beloved Master Muhammad sallallahu alayhi wa alihi wa sahbihi wa sallam. What does it read as? It says, لَعَنَ رَسُولُ صلى الله عليه وسلم آكل الربا ومؤكله وكاتبه وشاهديه. The Prophet sallallahu alayhi wa alihi wa sallam has cursed, and generally when a certain issue is cursed in terms of Islamic legal theory, then that particular action is considered to be proscribed, and Allah SWT knows best. So the Prophet ﷺ cursed the person who consumes riba and the person who gives the riba. So in other words, both the lender as well as the borrower. It goes beyond that. وَكَاتِبَهُ, the person who writes it, the scribe who records down this particular transaction. وَشَاهِدَهُ or وَشَاهِدَيْهِ, and the witnesses to that particular usurious transaction. So what have we done thus far? We've basically looked at the definition of riba. It has a literal meaning, which means to increase. In detail, we've looked at the technical definition of riba, and then we've looked at the proofs that seeks to prohibit and proscribe riba. We now continue with the lesson bi'idhnillah subhanahu wa ta'ala, and the next part of the lesson reads as follows. Before we getting into the text, we're going to look at the three types of riba. So this comes basically from the explanatory notes. There are three types of riba. Keep the definition in mind, and then we will look at the three types of riba. They all fit squarely into the definition which we have already given. What is the first type of riba? The first type of riba is referred to as riba al-fadl. So we look at that particular construction, riba al-fadl. It's mudaf ilay, that riba that incorporates an increase. What is that all about? وهو البيع مع زيادة أحد العوضين على الآخر. It is a sale where you find the price and you find the counter value. Now, either in the price or the counter value, there is an increase. So the example we gave at the beginning in terms of our definition would be that I am selling 15 grams of gold in exchange for 10 grams of gold. This type of riba is referred to as riba al-fadl. Why? The word fadl means to have an increase, an excess. So we find 10 grams of gold. For 10 grams of gold, that is fine. But on the one side of the equation, there's an extra 5 grams. And these commodities happen to be usurious. And when you're exchanging usurious commodities, they must be tamathul if they belong to the same genus, if they belong to the same generic group, and Allah subhanahu wa ta'ala knows best. So again, that same idea, there are 3 types of riba. The first type is referred to as riba al-fadl. Fadl means an increase. What is this? This is when we have a sale and there is an increase on one side of the equation, 15 grams of gold for 10 grams of gold. I'm going to read the Arabic and then we can do the translation. Riba al-fadl wa huwa al-bay'u ma'a ziyadati ahad al-iwadain. It is a sale where one part of the contracted item is more than the other and they're supposed to be equivalents, and Allah subhanahu wa ta'ala knows best. That's a very simple and easy form of riba to understand. The next one would be riba al-yad. Riba al-yad. The word riba again means to an increase and now relates to al-yad. وهو البيع مع تأخير قبضهما أو قبض أحدهما. What happens? So we're talking about a riba that relates to the hand. What happens here? We will come to learn later that one of the conditions, one of the added conditions when you are trading in a usurious item would be that possession of the price and the counter value must take place immediately. If there is a delay in terms of either taking hold of the price or the counter value, in other words, you don't apply your hand, your non-application of the hand leads to riba al-yad, a usury which ties into your hand. In other words, you did not take possession of the price or the counter value. That is referred to as riba al-yad. There must be a reciprocal taking possession of the price and the counter value. If that's not done in a usurious transaction, then that amounts to riba al-yad. The last riba which we're going to be doing for today, or rather the last part of riba in terms of its division, there are 3 types: riba al-fadl, riba al-yad, and the last one reads as riba al-nasi'a. Now the word nasi'a basically means to defer. So it is a form of riba, it is a form of usury which happens in a sale contract. And how does it come about? It comes about as a result of a deferment. وَهُوَ الْبَيْءُ لِأَجْلٍ. So I sell you 15 grams of gold, or I sell you 10 grams of gold, and then what happens is that I give you the 10 grams now and you're going to give me your 10 grams in a week's time. That is part of the contract. It could be cash, but we just don't take possession. That's riba al-yad. But riba al-nasi'a is when the contract itself stipulates that I'm going to give you the 10 grams of gold now and you're going to give me the 10 grams of gold in a week's time. In other words, it is deferred to a stipulated time. That is considered impermissible, and we refer to that type of riba as riba al-nasi'a, and Allah subhanahu wa ta'ala knows best. Let's continue with our reading bi-idhnillah subhanahu wa ta'ala. And now, I wouldn't say finally, but that particular preamble, that particular exordium, which covers a number of very important points. What were they? We looked at the definition literally and technically. Then we looked at the different types of riba and we listed them as 3. With that particular exordium, we're now coming into the text, the core text of Umdatul Salik. Let us look to that now, bi-idhnillah subhanahu wa ta'ala. It says, but before we get there, subhanallah, one last aspect, and I thought to mention this because it's very important. It's very important because one cannot discuss riba except to be assailed by the consequence of riba. One of the, or according to certain scholars, the most severely condemned act in terms of Quran would be riba. Why is that? Because Allah subhanahu wa ta'ala declared war against a person who consumes riba. فَأْذَنُوا بِحَرْبٍ مِّنَ اللَّهِ وَرَسُولِهِ. The verse goes as follows: وَذَرُوا مَا بَقِيَ مِنَ الرِّبَا إِن كُنتُم مُؤْمِنِينَ فَإِن لَمْ تَفْعَلُوا. If you don't do that, in other words, if you don't desist from consuming interest, from engaging in interest, from exacting interest, فَأْذَنُوا بِحَرْبٍ مِّنَ اللَّهِ وَرَسُولِهِ, then let it be known, فَأْذَنُوا بِحَرْبٍ مِّنَ اللَّهِ وَرَسُولِهِ, that you have declared war against Allah and His Messenger. There is no sin, according to certain scholars, wherein Allah subhanahu wa ta'ala had declared war against its perpetrator, except for that of riba. And here, in terms of the explanatory notes, we find there's a narration, and this narration is recorded in the Mustadrak of Imam Al-Hakim. He has the following to say from the Prophet sallallahu alaihi wasallam. It reads as Ar-Riba sab'una baban, that riba is multifaceted, multifarious, multifaceted. It has 70 doors, sab'una baban, aysarahuma, and the lightest of these doors. So all forms of riba would be prohibited, and the least form of riba, this particular narration says, is likened to. It's not the same, but it's likened to. My understanding of this particular narration is to impress upon us the severity of consuming interest. May Allah subhanahu wa ta'ala protect all of us, particularly in the times that we live in. We live in a time where if you are not actively engaged in terms of riba, then we will be affected by the effects thereof. Our responsibility would be for us to do our level best, fattakullah mastata'tum, and steer clear of that which is outright riba. This particular narration says the least form of riba is likened to something. What is it likened to? أَيَنْكِحَ الرَّجُلُ أُمَّهُ, that a person, the word nakaha yankihu has two meanings. The one is for a person to enter into a marriage contract, and the other one is to enter into not a marriage contract, but to engage in sexual activity. And the second meaning is what is applied here, أَيَنْكِحَ الرَّجُلُ أُمَّهُ, that a person has sexual intercourse with his mother. In other words, it is tantamount to incest. So the least form of riba is tantamount to incest, and Allah subhanahu wa ta'ala knows best. May Allah subhanahu wa ta'ala save us. So now that brings us now to a completion of the exordium as provided by Imam Al-Biqa'i. We now go into the text of the Umdah bi'idhnillah subhanahu wa ta'ala, and it reads as follows. Let me get to the text bi'idhnillah subhanahu wa ta'ala. One moment. The first part of the text for fil mustadrak, and we've covered that, and now لا يحرم إلا في المطعومات والذهب والفضة. So the text now, very importantly, I think in terms of the fiqh text, the fiqh text represents what we find in terms of Quran in the way of the Prophet sallallahu alaihi wasallam. You might find that yes, riba is something which is prescribed, but we shouldn't be industrious in terms of extending this particular prohibition. And the spirit of the text, of the fiqh text, supports that idea. It says, La yahrumu illa, that riba is not prescribed, illa except, and it's going to give a very limited list of 6 items. And when we look at these 6 items and we understand the ratio legis, we're able to extend it to other goods as well that share in the same underlying reasoning. But still, even with that particular extension of the ruling, it is still limited to an X amount of goods. And this is the nature of things which are prohibited in Islam. It is very, very limited if you compare that which is prohibited to that which is permitted in terms of Islam. And then there is a vast contrast in terms of that which is allowed, which is the bulk, and that which is not allowed is very limited compared to that. I remember reading something of Imam As-Sarhindi rahimahullah, and he's talking about a person who gets himself caught up in the disobedience of Allah subhanahu wa ta'ala. He really addresses the person in a pitiful manner, that you ignore the vastness of that which is permissible, and then you busy yourself with the limited sphere of that which is impermissible. That shouldn't be. May Allah subhanahu wa ta'ala guide us. So here the text, لا يحرم إلا في المطعومات والذهب والفضة. The text reads as follows, لا يحرم, riba is not prescribed. In other words, it's not applicable إلا في المطعومات, except in mat'umat. The word mat'umat is the plural of mat'um. Ta'ama means to eat, food, a foodstuff, except in foodstuff. Riba doesn't apply except in foodstuff. We are now looking to create a list of usurious items, because when we're dealing with usurious items, then certain added conditions apply over and above the conditions which we had discussed before when it comes to the contracted item in terms of the commodity and the counter value. So the author says, لا يحرم إلا في المطعومات. It is not impermissible except in foodstuff. والذهب والفضة. And it goes on والذهب, and in gold and silver. Now when we look at this particular text, we can unpack it in a particular way, and the unpacking is the responsibility that of the next slide bi'idhnillah subhanahu wa ta'ala. And this is how we've done the application. The application is very simple. So the text reads, riba is only prescribed in foodstuff and gold and silver. The foodstuff are basically going to be 4, and the gold and silver is going to be 2. That makes basically 6 items. So when we look at the application gold and silver, we're going to talk later a little bit more about gold and silver and what the ratio legis is. I'm going to leave that for later. For now, we're going to focus on wheat and barley. So the hadith, which we're going to repeat a few times, inshallah, in terms of the lesson, reads as follows: الذهب بالذهب والفضة بالفضة. Gold for gold, silver for silver. والبر بالبر والشعير بالشعير. Wheat for wheat and barley for barley. So now, is it only wheat and barley that are considered to be usurious items, or do we look at wheat and barley and we identify a ratio legis and we say this is a cereal, and by extension all cereals are considered to be usurious items? That's exactly what our Shafi jurists do. So the reasoning would be wheat and barley are considered usurious, then maize, rice and full by extension are also considered to be usurious. Why? لأن المقصود من البر والشعير التقوت. Because the objective in terms of wheat and barley is really the staple food. So anything which can be considered as a staple food, a cereal, is going to be considered as usurious. So let me give you a very quick example, bi'idhnillah subhanahu wa ta'ala. If you're trading wheat for wheat, it must be 1 kilogram of wheat for 1 kilogram of wheat. Barley, 1 kilogram of barley for 1 kilogram of barley. There must be equivalence in terms of the price and the counter value. Do we limit it to those 2 goods? No, we extend it. Any other cereal. A cereal, in other words, in terms of a staple food, rice would fall squarely into that particular category. So when I'm exchanging rice for rice, I'm selling rice to you for rice. I'm selling you tastic and you giving me basmati. Because it's considered to be a usurious item, by extending the ratio legis, we now consider rice. Rice must meet the stringent conditions of a usurious contract, and that is equal for equal, like for like, and hand for hand. We get back to our PowerPoint slide, and now we look to the next one, wheat and barley, and then the Prophet ﷺ talks about dates for dates. When you're exchanging dates for dates, again, it must be equal for equal. Are we going to limit it to dates? No, we're going to extend it to go beyond dates. What is considered to be exactly the same like dates? Here we have 2 examples. The first one be raisins. The next one is figs. Why did we add raisins and figs? Because raisins and figs, they share in the same reasoning like dates. لأن المقصود منه التقدم والتفكه. The idea behind dates is that dates serves as a condiment, if you so wished, and whatever else serves as a condiment to food. In other words, it falls under the broad ambit of food stuff, really. It's just that the nice part of these explanatory notes would be that they look at each food stuff and they basically add food stuff to it that fall within the same category, and Allah subhanahu wa ta'ala knows best. But if you wanted to, you could simply say that the 4 items of food stuff, and therefore any other food stuff would also be considered to be usurious, and Allah subhanahu wa ta'ala knows best. The last category here talks about salt. So salt for salt. Now when we look at salt, what is the objective behind salt? لأن المقصود من الملح الإصلاح. They say, in terms of Arabic grammar, they say النحو في الكلام كالملح في الطعام. Grammar in terms of language is like salt in terms of food. Food without salt doesn't taste right. So in other words, for islah means to reform something, to make something good, to make something wholesome. So salt is added for that particular purpose. So any other food stuff that serves the same purpose is going to be considered exactly the same, and therefore a usurious item, and the conditions which we are going to mention applies to those as well, and Allah subhanahu wa ta'ala knows best. So we have salt. Under salt we have scamonia, and then we have za'faran. I've added a note here, and Allah subhanahu wa ta'ala knows best. It's a sort of a salt, a salt-like substance like za'faran, and it's added as a what does salt serve? It preserves, it adds taste, and it has medicinal properties. The same would apply to scamonia and so forth. I googled scamonia, not knowing exactly what it is. It's a type of root that is used. It's a type of wild weed really, but the root and other parts of the plant is used for different medicinal properties. A person has worms and so forth within his gut, and he seeks to remove these worms, kill off these worms, he's going to eat scamonia in that particular regard. Just to give us a bit more about that, barakallahu fikum. We now go back to the slide, bi'idhnillah subhanahu wa ta'ala, and we go to the next part of the text. So we had in breaking down the four food stuff and then looking at the gold and silver, we had sort of like moved around the underlying reasoning, but now we're going to go into that in detail bi'idhnillah subhanahu wa ta'ala. وَلَعِلَّةُ فِي تَحْرِيمِ الْمَطْمُوعَاتِ الطَّعْمُ. When we do a study of the four items, in other words, the barley, the wheat, or rather let's go in terms of the order, the wheat and the barley and the dates and the salt. When we look at it, we find it is food stuff. Why has these food stuff been considered to be usurious? We can think of a number of properties in relation to the food stuff. We can think of a number of properties. You could think that, look, these items, when they are sold, they are weighed. These items, when they are sold in terms of volume. You can think of a number of reasonings. The reasoning which the Shafi'i jurists have applied to these narrations of the Prophet ﷺ, when they look at those particular four items, they say that these items, they are usurious. Why are they usurious? We know it's very clear that it's a food stuff, but it's a food stuff, very obviously, but why has it been regarded as usurious? In other words, what trait exists within these food stuff that Allah subhanahu wa ta'ala had labeled it as usurious? According to the Shafi scholars, it is because, exactly for that reason, it is because it is a food stuff. There's a narration where the Prophet ﷺ says, "At-ta'amu bit-ta'am, mithlan bi-mithlin," that food for food. So he doesn't mention the goods in terms of listing them out. He says food for food. So that's very similar, our scholars argue, to the argument of az-zaniyatu wa-zani fajlidu kullu wahidin minhuma. Allah talks about the adulterer or the fornicator. In this particular instance, it's going to be the fornicator, that they're going to receive a number of lashes. So why are they going to be receiving a number of lashes? Because of the fornication. So the reason is contained within the wording. So here, in this particular narration, the Prophet ﷺ is using the wording at-ta'am bit-ta'am mithlan bi-mithlin. So the very wording, it indicates to the reason why it is deemed as usurious, and Allah subhanahu wa ta'ala knows best, and that is in terms of our school of thought. So the text in terms of the Umdah reads وَالْعِلَّةُ, the underlying reasoning. And to understand the underlying reasoning in terms of Islamic legal theory, what would that mean? It would mean al-hukmu yaduru haythuma taduru al-illah. Wherever the underlying reasoning is to be found, that's exactly where you're going to find the ruling as well. وَالْعِلَّةُ فِي تَحْرِيمِ الْمَطْعُومَاتِ الطَّعْمُ. So the underlying reasoning for the impermissibility of food stuff would be exactly the fact that it is a food stuff, and therefore, according to the Shafi school of thought, any type of food stuff is usurious, and therefore the conditions need to be met, and Allah subhanahu wa ta'ala knows best. In other words, the stringent conditions over and above the conditions that apply to a contracted item, if it's a foodstuff that you are dealing with, and then these rules apply, and Allah subhanahu wa ta'ala knows best. وَفِي تَحْرِيمِ الذَّهَبِ وَالْفِضَّةِ كَوْنُهُمَا قِيَمُ الْأَشْيَاءِ. So before we get that, this is just another note that I remembered now in terms of the ta'am. Food stuff. What type of food stuff? You get food stuff that are peculiar to human beings. Only human beings consume those goods. Are they considered usurious? Absolutely. What about certain food stuff that human beings share with animals? Those type of food stuff, because humans consume it, is also going to be considered as a usurious substance. What about food stuff that are peculiar to non-human beings? For example, like bones. They are the food of our brethren, referring to the jinn kind. Would they be considered as usurious? No, they're not, because it's not our food stuff. And therefore, let's just say hypothetically, if a person were to trade bones for bones, and it's not considered a usurious item, so he has the latitude of a normal transaction in terms of discrepancy, in terms of amount, and then also in terms of buying on credit, deferring either the commodity or the counter value, and Allah subhanahu wa ta'ala knows best. Then the text goes on. Remember, the hadith talks about 6 things. It talks about the 4 food stuff, so we're done with that. In relation to gold and silver, according to the Shafi'i school of thought, they consider gold and silver to be usurious. Everybody agrees upon that. But now, what is the reason why it is considered usurious? When you look at gold and silver, you can again argue gold and silver is exchanged in terms of weight. 1 gram of gold for another gram of gold. Is that the reason why it's considered impermissible? Therefore, anything else that you weigh, for example, like metal, is also considered to be impermissible. Our scholars here say that the reason why gold and silver has been earmarked as a usurious item is because the underlying reasoning is because it is a money commodity. It is money commodity, thamaniya. The interesting thing in terms of the Shafi school of thought, in at least in terms of our classical works and so forth, they say that is the reasoning. So can we extend that reasoning to apply to anything used as money, like currency, even though it may not be money commodity as such? Technically speaking, our scholars say no, and they would look at something like fulus, which would be like a sub-currency at the time. You had gold and silver, and then you have fulus, like we have rands, but then we have cents as well. So we have notes and we have coins. So something similar to that. Does the ruling of thamaniya apply to your fulus currency? Our scholars say no, it doesn't apply. What if that becomes the order of the day? Even if it becomes the order of the day, they say it doesn't apply to that. In modern times, in today's time, that would lead to certain absurdities. What would the absurdities be? I'm just approaching the issue from one angle. The absurdities would be that if riba doesn't apply to those commodities, and then zakah is not going to comply to those commodities, and practically people will be exempt from two very important phenomenon within our fiqh, and that would be zakah on the one hand in terms of paying zakah, and on the other hand in terms of engaging in using Allah subhanahu wa ta'ala knows best. So that particular very simple argument lays to rest any counter arguments in terms of not applying the laws of riba and zakah to our fiat money, to our currency, and Allah subhanahu wa ta'ala knows best. We go on to the next issue now, bi'idhnillah subhanahu wa ta'ala. The next issue reads as follows. Now, so now we're going to look at the conditions relating to a usurious transaction, and this up until the class now you have a basic but good understanding, inshallah, in terms of what the conditions are. Here it is mapped out for us. The text reads as follows: فَإِذَا بِيَ مَطْعُومٍ بِمَطْعُومٍ. You see the language has changed now, because we've already taken a step in the direction whereby you now understand that it's not limited to wheat and barley, dates and salt. No, we've extended that and to apply to all foodstuffs. And now the text reads فَإِذَا بِيَ مَطْعُومٍ بِمَطْعُومٍ. When is sold a foodstuff for a foodstuff, min jinsi, belonging to the same generic group, min jinsi, belonging to the same generic group. كبر ببر, like a wheat for wheat. اشترط في بيعه ثلاثة أشياء. Then in this particular usurious transaction, and I just remind you in terms of our definition, what is the definition? The definition says عقد على عوض مخصوص, that riba refers to a contract. What is contracted? A certain type of commodity which we refer to as usurious. And here you have an example of it. What is the example? Wheat for wheat. Now when you're exchanging wheat for wheat, right? اشترط في بيعه, it is stipulated in terms of the sale ثلاثة أشياء. 3 things are stipulated. Very important for us to understand. If any of these conditions are not met, and then what are we going to say? Then is غير معمول التماثل في معيار شرعي. That is not going to be considered to be correct in terms of the Sharia. In other words, from a Sharia legal perspective, it's not going to be considered to be correct. So when you're exchanging one goods for another goods, and these goods belong to the same generic group, like wheat for wheat, 3 conditions are stipulated. What are those conditions? Number 1, it says al-mumathalatu. The first condition says al-mumathala, there must be equivalence, mithl. In other words, on both sides of the equation, 10 grams of gold for 10 grams of gold. We're doing an example of wheat. 10 kg of wheat for 10 kg of wheat. 10 ton of wheat for 10 ton of wheat. That's the first thing. And then also the equivalence must be known. We can't estimate and tell ourselves, look here, they are more or less the same. No, if you're exchanging wheat for wheat, then you must be certain this is 1 ton a ton bag for another ton bag, a ton for a ton. It must be known. If there is any doubt, then our scholars say that it would not be permissible. Why? Because there's a rule, and the rule reads as follows. They say al-jahlu bil mumathala, not knowing the equivalence. In other words, you're not certain about the equivalence. You don't have a certainty in terms of the equivalence. Then that is tantamount ka haqiqati. I have mumathala written, that's completely incorrect. كحقيقة the opposite of mumathala. Let's call it كحقيقة غير المماثلة. So not ignorance of equivalence is tantamount, it's almost like that is not equal. So when you doubt that it's equal, then the Sharia construes that as it not being equal, and therefore it's not going to be permissible. Even though post the contract, when you actually weigh it out and you say, look, alhamdulillah, it was 1 ton for 1 ton, that transaction is still impermissible. Why? Because at the time of the contract, you were not certain in terms of the equivalence, the unity in terms of the contracting items, in terms of the amount. Even though retrospectively you discover that it actually was equal at the time of the contract, because you doubted whether it was equal. So a doubt as regards to its equivalence is tantamount to its inequivalence, and Allah subhanahu wa ta'ala knows best. So the first condition is there must be equivalence when you're trading one genus for another genus. Number 2 is the contract itself, in terms of the construct of the contract, it must be cash and not deferred. And the last condition would be at-taqabud. If I'm selling a ton of wheat to you and you're purchasing a ton of wheat from me, then I must take your ton and you must take my ton, and Allah subhanahu wa ta'ala knows best. We now move on to the next part bi'idhnillah subhanahu wa ta'ala. وَإِن كَانَ بِغَيْرِ جِنْسِهِ كَبُرٍ بِشَعِيرٍ أُشْتُرِطَ شَرْطَانِ. Alternatively, if it is that we are exchanging بِغَيْرِ جِنْسِهِ. So here, just to make things more clear also, when we look at the 6 commodities, what our scholars have done very uniquely really, because they're not just looking at one narration, they're looking at all of the narrations relating to usurious items. And as a result of holistically looking at all of the narrations, they've come to the following conclusion, that when we look at the 6 commodities mentioned in the narration, we divide them into 2 categories. The first category would be the foodstuff, and the second category would be the gold and silver. Now what happens is, if you're exchanging anything in the first category, in other words, wheat, barley, dates and salt, if you're exchanging the one for the other, you're exchanging the one for the other. For example, wheat for barley. So now it belongs to the same group, but from a different genus, from a different generic group. In other words, it's like a different universal altogether. So وَإِن كَانَ بِغَيْرِ جِنْسِهِ, if you're selling a usurious item for another genus like wheat for barley, كَبُرٍ بِشَعِيرٍ أُشْتُرِطَ شَرْطَانِ, then 2 conditions are stipulated. What are those 2 conditions? Al-hulul, it must be cash. In other words, the construct must be that it's not a deferred, it's not a credit transaction, it is a cash transaction. In other words, you're going to get your barley now and I'm going to get my wheat now. وَالتَّقَابُضْ قَبْلَ تَفَرُّقٍ, and then it is necessary that you take possession of the wheat, I take possession of the barley, or vice versa. قَبْلَ تَفَرُّقٍ, before we physically move apart. وَجَازَ التَّفَاضُلِ, in this particular instance, discrepancy would be permissible. So in other words, I give you 1 kilogram of wheat and you give me 2 kilogram of barley, no problem, no questions asked, and Allah subhanahu wa ta'ala knows best. وَإِن بَاءَ نَقَدًا بِجِنْسِهِ, we're giving just another example, but this is now when we move to the other category. Remember, there are 2 categories, the 4 food stuff fall into one, and then the 2 money commodity fall into the other category. Now what's happening is, I'm selling gold for silver, not gold for gold. Then 3 conditions are stipulated. But if I'm selling gold for silver, then 2 conditions. What are the 2 conditions? The 2 conditions are the contract must be cash, number 1, and number 2 is reciprocal taking possession must occur. So a contemporary example would be when I'm going to the foreign exchange and I'm exchanging silver for gold, or rather I'm exchanging money, rands for dollars, or Canadian dollars for American dollars, whatever the case may be. If that is the case, وَإِن بَاءَ نَقَدًا بِجِنْسِهِ, if a person is selling money commodity for the like thereof, I'm exchanging rands for rands, كَذَهَبٍ بِذَهَبٍ, like gold for gold, اشترط الشروط المتقدمة. Then the three conditions which we spoke about, those same three conditions are stipulated. What are they? They must be equivalence, it must be cash, and reciprocal taking position must take place. However, وإن باء بغير جنسه, if you are selling for other than its generic group, you're selling gold for silver, كذهب بفضة, gold for silver, اشترط الشرطان وجاز التفاضل. Then اشترط الشرطان, two conditions are stipulated, وجاز التفاضل, and then an equivalence would also be allowed, and Allah subhanahu wa ta'ala knows best. We go on to the next part of the slide, bi'idhnillah subhanahu wa ta'ala. What falls outside the ambit of riba? And this is a very interesting phenomenon. What falls outside the ambit of riba? We established at the beginning that what falls within riba is very limited, because the fiqh text reads, and this is gleaned from the narrations and from the Quran itself. What is gleaned there from? لا يحرم إلا, that it is not impermissible except in certain instances. So we've looked at those particular instances. What happens now when you look at the narration and you find it's 4 on the one side and 2 on the other side? We've spoken about, you have one, for example, like you have wheat for wheat. If you're doing wheat for wheat, then 3 conditions apply. If you're doing wheat for barley, then only 2 conditions apply. What happens now is you have the 4 on the one side and you have the 2 on the other side. And now I'm giving you silver and you're going to give me wheat. What happens in that particular instance now? Do they belong to the same generic group? No. Do they belong to the same category? No. You're selling from the one category to the other category. That would be like a normal run-of-the-mill type of sale where you're using money commodity or you're using currency to purchase a given item. What happens in that particular instance? Are there any restrictions? Does this fall under the ambit of riba? This is very interesting because if you think about something which goes about, they say that if you sell something for cash and you have a cash price, I sell you the computer for 10,000 rands cash. However, if you're paying me over time, you're purchasing the item on credit, installments, you're going to pay me 1,000 rands a month, I'm going to sell it to you for 12,000 rands. So some of the opinion, it's really not a substantiated opinion, it's not a valid opinion. They say that amounts to riba. How does it amount to riba? In terms of our breakdown, it doesn't fall under the ambit of riba. It falls outside of the ambit of riba. Now, when something falls outside of the ambit of riba, it's no longer considered a usurious transaction, and then the latitude is as per the default normal. In other words, you can sell on credit, you can sell cash, you can determine whatever price you want. Mumathala is not considered to be a condition. The text says, وَإِن بَاءَ مَطْعُومًا بِنَقَدٍ. If a person sells a foodstuff, in lieu of what? وَإِن بَاءَ مَطْعُومًا بِنَقَدٍ. If a person sells a foodstuff in lieu of a money commodity. So I'm buying wheat from you and I'm going to give you a silver coin. صَحَّ الْبَيْءُ مُطْلَقًا. The text says the sale would be valid mutlaqan, unrestrictedly. In other words, there is no restrictions which apply in this particular regard. So an example would be if a person is exchanging like a barter, he's exchanging what is he exchanging? A piece of clothing, an item of clothing or items of clothing for a camel. So you find on both sides of the equation, it's not a usurious item. Animals aren't usurious items and clothing is not. So mutlaqan, the sale would be valid. Alternatively, if you find on the one side of the equation, I'm selling you an item of clothing and you're paying in money. So on one side of the equation, we find a usurious item. So, and on the other side, there's no usurious item. Then all of those added conditions in both instances, all of them fall away, and Allah subhanahu wa ta'ala knows best. I speak under correction, but this should be, if not the last, one of the last slides. It's absolutely the last one. Our next lesson would be riba continued. How do we measure equivalence? We've spoken quite a bit in terms of like for like. That when it's a usurious item, it must be like for like. How do we determine that equivalence? In our next lesson, bi'idhnillah subhanahu wa ta'ala, we will basically look at that. We touch slightly in terms of one rule, that when you are not certain in terms of the equivalence, then that is tantamount to having non-equivalence. But other than that, when we are trading in certain items, the Sharia actually is quite prescriptive in that particular regard in terms of telling us how equivalence should be established. And if we don't establish equivalence along those lines, then it is considered to be non-equivalent, and that falls into the ambit of riba. But more about that in our next lesson, bi'idhnillah subhanahu wa ta'ala. Barakallahu fikum jami'an. Wassalamu alaikum wa rahmatullahi ta'ala wa barakatuh.